Let's head now to the Constitutional Court, because it will today hear arguments in what is going to be a landmark case, particularly about consent when it comes to sexual offences, including rape. In terms of the Sexual Offences and Related Matters Act, a person that is charged with rape can actually avoid conviction if they can show that it is reasonably possible that they believed the complainant had consented to sex. Now, this defense does not require showing that consent was actually given. Last year, the High Court in Pretoria ruled that certain provisions in the Sexual Offences Act were unconstitutional because they failed to protect victims. Zoleka Qodashe joins us live from Constitutional Hill with more on this one. It's really going to be a landmark case and a significant one when one considers just the state of gender-based violence and how it would then be enforced and really treated when it comes to the judiciary post this ruling. Good morning, Zoleka.
That's right. Good morning, Arabile, and certainly will have legal implications for other rape matters. You'll remember the Qodashe matter that was in the High Court in Makhanda, where the court had initially found that the defense by the accused person who was accused of rape was reasonably possibly true. And that is the subjective test that the applicants before the Constitutional Court want to do away with. They previously argued before the Gauteng High Court in Pretoria that the provisions are of the Sexual Offences and Related Matters Act are unconstitutional because they allow that unreasonable and wrong belief by an accused person that consent was indeed granted. Now, the applicants will argue the same before the Constitutional Court today, seeking a confirmation of a declaration of constitutional invalidity that was granted by the High Court in Pretoria that essentially granted their order that the various provisions, that's 3 to 9 of the statute as well as 11A, are unconstitutional insofar as they allow an accused person to argue that they had the belief that consent was granted. Now, in criminal matters, there's always a subjective test where the accused will be, or the court looks at whether the accused's version is reasonably possibly true. Now, what the order of the Gauteng High Court in Pretoria did is that it said that that will no longer be a valid reason for an accused person be in rape matters, and instead, accused persons must demonstrate to the court that they took objectively reasonable steps to ensure that consent was granted. Of course, objectivity is a legal standard as well, and there is a test for this, which is the reasonable person test. What the reasonable person test does is that it asks two questions. One, would a reasonable person in the same situation as the accused person have foreseen the incident or the cause of harm that they would have inflicted upon the complainant? And two, is would the reasonable person would have taken reasonable steps to ensure that the harm would not be caused. Of course, that is what the order of the Gauteng High Court granted to the applicants, one of whom is alleged to be a rape survivor. Now, what the applicants seek today is a confirmation of that constitutional invalidity that was granted by the Gauteng High Court in Pretoria, but also to say that the order of constitutional invalidity is suspended for a period of 18 months. This is the order that was granted by the Superior Court, or the Qodashe, last year in September 2024. But what they also seek is that if Parliament fails to remedy the defects or fix the unconstitutional aspects of the statute, then what has the reading in that has been provided by the Gauteng High Court in Pretoria becomes final. Now, what you often see, Arabile, in matters where there is a reading in that has been provided by a court is that after the period of suspension has lapsed, that reading in, that addition to the statute that has been provided falls away. So what we will see in 18 months, if the Constitutional Court grants that order and confirming the unconstitutionality of the statute, is that additional reading in that's been provided by the court of quo falls away, which means, according to the applicants, that victims or potential targets of gender-based violence will continue to suffer that fate. So they want that reading in to become final in the event that Parliament fails to rectify the unconstitutional aspects of that particular statute. What we're expecting to see is that those proceedings will kick off at 10 a.m. with the applicants arguing their matter. Of course, there's also amicus in the matter who will assist the court in arriving at a determination. But for now, it's back to you in studio.